Good afternoon and welcome to our June seminar on the top 18 legal traps for Queensland real estate agents. It's good to have you with us today. So for most of you, PAMDA is well and truly a distant memory, but there are a number of changes afoot that make this presentation today timely, and no doubt you're all aware of the new contract editions that are being circulated by both REIQ and ADL. And not only that, electronic conveyancing is very near. So with those changes occurring, it's timely to have a look at issues about contract presentation, compliance, and sales. So before we get started though, as we usually do, I'd like to just get a feel for who's with us today. So if the first poll is, what industry are you from? So I expect we'll have a lot of real estate agents, but there might also be legal and finance people. So it will help us tailor the answers and the way the presentation is directed. Okay, answers are starting to come in there now. We'll leave that open for a few more seconds. Okay, all right, so we'll close that off now, and you'll see that the majority of attendees are from the real estate space. All right, second question I'd like to put to you is just get a feel of what your role is, for example, at the agency or in the other position you occupy. Again, this will help us tailor how we pitch today's presentation. Okay, we'll leave that open for about another 10 seconds. Thank you for your responses. Okay, well, we have a big proportion of owners and sales, so it's good to see that we have that level of participation so that we can convey what I think are the most important traps that agents need to be aware of. Okay, the first trap, legal trap number 18, incomplete contract details. Now this is an oldie but a goodie. Most agencies are very well attuned to the need to complete the reference schedule in the contract accurately, but there are still errors that we see. Most significantly, it relates to the names of the parties, the buyer or the seller. Now, an incorrect name, an incomplete name, can require, in some cases, deeds of rescission, and it involves, at the very least, the parties in additional legal expense. So that's a trap for young players. Easements left out. Obviously, most of you would be aware of the necessity to get a copy title before completing a contract, before preparing it for anyone to sign. Very important to ensure that encumbrances are properly listed. Inclusions. Sometimes we see items of this type left off the contract when it was clearly intended they ought to be included. And exclusions, for example, the seller might want to take something that's fixed. So they're the things that we see errors in from time to time, and the things that constitute a legal trap for agencies. Consequences here are civil liability, usually to the seller. So be aware of that one. Before we go on with our next 17, if we can just get you to complete this information, I just want to get a feel of which forms supplier our audience is using today: REIQ, ADL, solicitor custom contracts, or none of the above. Okay, that's good information. The REIQ new contract obviously came out in May, and the ADL one just last week. Okay, we'll close that off. There's the information. So it's I'm very grateful to have that information, and it'll help me pitch what we are going to say today. All right, legal trap number 17, not conducting a tree inventory. Now, since 2011, we have the Neighbourhood Dispute Resolution Act, which gives valuable rights to owners and neighbours, depending on the longevity of their occupation in the property. So it's important for agents to get a handle on what problems the buyer might inherit and what rights they might lose once the contract is signed. Those of you who attended our tree law seminar last year will be familiar with those issues. The consequences of not doing that is potentially a disappointed buyer if they inherit a significant problem relating to an obligation to remove large trees, or they might be disappointed that they couldn't have exercised the rights the seller had to demand the neighbour trim trees that are obstructing a valuable outlook. So conduct a tree inventory. I'm just reminding you here that the information contained in this webinar is of general nature, and you should always get specific advice, or rather your client should, in relation to any particular circumstance. Legal trap number 16 for agents, ad-libbing on special conditions. Now, you're all aware that you can use special conditions or inserts into contracts from a solicitor source, but you can't ad-lib on those special conditions. You can't yourself vary them. So what are the consequences? Well, it's an offence and it creates potential civil liability if what you're doing doesn't convey the effect that the parties might have intended. Or, for example, if there are different interpretations, then it might expose the agency to the legal costs of either or both parties. Moving on, we should have just right amount of time to get through these 18 today. Number 15, not providing for land tax adjustment. Now, no doubt many of you are aware that the new REIQ contract, and I'm not sure about the ADL one, I haven't checked it yet, does not provide for the seller's land tax to be adjusted. That means that the seller is liable for all the land tax, regardless of when a contract settles after the 1st of July. So this will become a bit of a sleeper. The problem will arise as from the 1st of July this year. Sellers are used to having land tax adjusted automatically, but that standard condition has now been changed. And if a seller wants a land tax adjustment to take place, a special condition must be inserted. So one would think that well, certainly that'll have consequences of there being disappointed sellers, and if agents don't alert sellers to that possibility and the need for potentially getting legal advice on the subject, it might open them up to potential liability to that seller. I can hear the sounds now. I can hear the voices. You didn't warn me about there being no land tax adjustment as from the 1st of July. Okay, moving on. Legal trap number 14. We still see this a lot, giving a buyer an unsigned BCCM disclosure statement in community title situations. Section 206 clearly says that the statement must be signed by or on behalf of the seller, and it must be given to the buyer before they sign the contract. Now, the consequences there can even lead to contract termination and potentially civil liability. Okay, well, we've got through our first 6, and it's just time now for another poll. I'd just like to get a feel for those of you joining us today who are already a subscriber of our agent, developer and investor e-news. That's the once a month e-news bulletin that we circulate to agents and others interested in the subject relating to developments in real estate practice, contract compliance and other eventful issues. Okay, so good to see we've got a number of you there. We'll close that off and share that information. Okay, so quite a number of subscribers. Now, so we've gone through number 14. Here we go to number 13, misleading conduct. This is certainly a legal trap, and it's not possible to have a waiver clause in a contract that says that the agent or the seller would not be liable for anything not included in this contract. That clause is in the contract, but it's ineffective. Regardless of such contractual provisions, the person who makes the misleading statements it does have legal consequences. So that things about future development potential, rental projections. We've even seen a contract recently where the agent described the property as air conditioned. It wasn't. There was an air conditioner installed, but it wasn't connected. So guess who ended up being liable for the cost of connecting it? So there has to be a basis for any statement made about the property you're selling, even if it's a heavily qualified statement, such as you must make your own inquiries. You still have to have a basis, a reasonable basis for making that statement. Otherwise, it can fall into the category of misleading conduct, and it can expose the agent and the seller to civil liability. So just remember also that silence as to important features of a property can also be misleading. Now we'll take questions if you're able to put them, send them in through the portal. If we have time at the end, we'll see if we can answer some questions. Legal trap number 12. We saw this recently, an inadvertent sale by an email exchange. This arises because a contract for the sale of real estate doesn't have to be in any particular format. It just has to be evidenced in writing. So it can come about simply by exchange of emails if all the important terms such as price and settlement date are specified. And as long as there's a clear offer and a clear acceptance, that can be adjudged a valid contract. Now, an agent who's expecting the next process to be the completion of a formal contract, at which time he'll seek formal instructions from his seller, could inadvertently conclude a contract where it wasn't intended to do so. So just remember that it can be a source of civil liability. The recent case concerned a roadhouse on the Atherton tableland. The agent did have some involvement in it, but it was really these emails exchanging between the buyer and seller which were sufficient to allow the Supreme Court to rule that a concluded contract had come into existence and the seller couldn't take advantage of a higher offer that had come, or that was already there, but hadn't been acted on by that stage. So we're up to number 12. I'm just going to do a brief recap on the ones we've seen so far. Number 18, incomplete contract details. Number 17, not conducting a tree inventory. Legal trap number 16, ad-libbing on special conditions. Legal trap number 15, not providing for a land tax adjustment, particularly after 1st of July this year. Legal trap number 14, giving buyer an unsigned BCCM disclosure statement. Legal trap number 13, misleading conduct, including by silence. An interesting example of that has been brought before the courts a few times, for example, where a house was the subject of a murder or some other gruesome activity, and that wasn't disclosed to the buyer when it was within the agent's knowledge. That's the sort of thing that can amount to misrepresentation by silence. So be careful of those sort of situations, and be careful of projections, because there has to be a basis for making the statement, regardless of how much you qualify it. So the statement about you must rely on your own inquiries, or this is from information that comes from another source, just simply aren't enough. It certainly is a legal trap of significant nature. Legal trap number 12, inadvertent sale by email exchange. Okay. Legal trap number 11. So this is a situation that in the warming market we have now, backup contracts are becoming familiar again. So, but it's important that there must be a correct backup contract procedure. The special condition inserted into the second contract must be precise and not expose any gaps between what might happen and what might not happen. So check your solicitor source for the precise special condition in those situations, and only use that special condition in those backup situations. Is there a conflict of interest issue? Well, the seller is the person whom the agent represents, and it's in their interest to protect the sale by getting a backup contract, but each buyer is still regarded as a customer of the agent. So there are potential conflict issues, so just be careful of those. You wouldn't want to be in a position where you could be said to favouring one or more of either of the potential buyers. Legal trap number 10, being a party to price rebates. So this practice is not so prevalent these days, but it was just a few years ago, where parties didn't seem to have any compunction about entering into a side agreement. For example, a seller accepting something less than what was stated on the contract. Now, usually that would be regarded as a fraud on the financier, because the buyer could go to the financier with a contract, and the financier thinks that a much higher price is being paid. So there are cases that also say it's potentially a fraud on other buyers in the market generally. So that's a real no-no. It's an offence, potentially indictable offence, and also creates civil liability. So don't be tempted to have anything to do with those type of arrangements. Legal trap number 9. If an agent is carrying marketing fees till settlement of the sale, it's important to specify that the fees are payable regardless of a sale occurring and by when. We have seen cases where an adventurous seller has said, look, you told me that the fees would only be payable if it was sold. Now that is very unlikely, I agree, but it involved the agent in a costly court fight. So that situation can be avoided by clearly specifying in your appointment that if you are carrying marketing fees, they are payable regardless of the sale occurring and by so many days following the end of the appointment. You don't want to be in a situation where another agent is appointed or the property is withdrawn from sale and you're left hanging. Legal trap number 8. Not getting Electronic Transactions Act consent. Now, this is this is the legislation that allows communication by emails, etc. The Act's provisions are drawn in loose terms, but to be safe, it's better to have the parties sign a consent to electronic communication before doing anything else in the transaction. And again, there's potential civil liability if that doesn't occur. The case I mentioned about the roadhouse on the Atherton tableland involved some consideration of this question, but there it was held that the conduct of the parties was enough to import consent, and that sending an acceptance by email to the address, to the email address of the party who'd been sending communications on the seller's behalf was sufficient compliance with that Act. The Act only covers electronic data transmissions. It doesn't cover document exchange, for example, by Dropbox. So if it might be important for you to, it's important for you to know that it doesn't cover that. I doubt it would be within the agent's responsibility to caution buyers or sellers about that. So if we could just pause here again, we're making excellent progress. I just want to get an idea of how good your understanding is of the new legislation that came into force in December relating to the Property Occupations Act. Are you completely on top of the new changes? Of course, we know that the PAMDA requirements have all been removed. It only took 14 years for that to happen. Someone should be held accountable. We just have to find out who. Okay, so we've got a good, we'll close that off now. So we've got a good representation of attendees who know about the new requirements, the simplified requirements, the main change, of course, being the abolition of the warning statement as a separate document and including a far briefer warning above where the buyer signs in the contract itself. And another poll, I just want to get an idea of how much people are aware of the latest changes in the latest versions of the contract, which REIQ issued in May and ADL issued their contract just last week. Okay, well, it's good to see that we're keeping ourselves informed. I'll close that off in a moment. Most of you know about the changes, but you're not yet fully on top of them. So please take the time to do that. We'll come to that in more detail in a moment, and I'll just give some more detail to it, knowing that there is some knowledge that seems to be wanted. Okay, legal trap number 7. Not getting the seller to sign off on property features. Now, the agent posts web adverts, does print advertising, prints brochures, etc., usually on the say-so of what the seller says is applicable to the property. But while sellers are required to approve advertisements, they're not specifically required to sign off on property features, and it has led to real problems. For example, there was a sale of a luxury unit in Riparian Plaza a couple of years ago where the seller instructed the agent there were 3 car parks, where in fact there were only 2. And the agent was embroiled in litigation for years over that. The seller bore some responsibility, but the agent, it was a portion between the agent on the one hand and the seller. So even though it all came from the misinformation provided to the agent by his seller. So there is a real trap there. Get your seller to sign off on what they say the property features are, and that's just protection, so you can have a callback against the seller. It won't necessarily protect you against the buyer, but it should allow you to, it's the starting point of allowing you to offload liability onto the seller themselves, where it should be. So the last thing you want to be, we've seen here that the consequences in some matters relate to offences, not getting commission. The worst consequence you want is civil liability. That's a never-ending bottomless pit, potentially bottomless pit, into which you can be drawn. So take those measures, those quality assurance measures, to ensure that you're not exposed to any civil liability in these sort of situations. Legal trap number 6. Now, we continually see cases where agents are after their commission where the sale occurs following the end of the appointment. That is perfectly reasonable. If the seller has made the introduction, if the agent has made the introduction during a valid appointment, why can't they get their commission even if it's sold by someone else shortly after, or even a significant time after? It used to be that the standard was simply, it still is, that the standard is simply who introduced the buyer and when, although the Property Occupations Act and PAMDA introduced another definition about being the effective cause of the sale. Now, that in fact comes from a legal analysis in the High Court of Australia about what constitutes the introduction of the buyer and what constitutes effective cause of the sale. So an agent can bolster their entitlement in this situation by defining that an effective cause of the sale is the introduction of the buyer during the appointment. So I recommend that to you to avoid the very disappointing situation of being of having a seller refusing to pay commission. Legal trap number 5. Insufficient information in Form 8. Now, we all know about the PAMDA Form 27C. I'm sure you can all remember it. Nothing's changed except the layout of the form. The disclosure that was required in the Form 27C is still required, notwithstanding the expectation that some of the requirements would be removed. That didn't happen. It must be said, though, that the Form 8 doesn't accommodate all the things that the Act says must be disclosed. So what the form does accommodate is disclosure of all relationships, parties to whom referrals are made, and the benefit received. So that's there. There's a good level of compliance in relation to that, as there always was. The other change is that the agent need not disclose their commission or fees. So that need not be disclosed. That's the new change from December. But what hasn't changed from December is that the agent must disclose the benefits received by any entity who is not the agent, where the benefit is associated in some way with the sale. So that includes a marketing company, lead generation, a commission to a financial planner, or payments made to runners. So all those things must be disclosed. The consequences of not doing it is an offence, and it can create potential civil liability, probably from the buyer who thought that a standard commission was being paid. So just remember that the last dot point there, that must be included in the document, regardless it must be disclosed, and the best place to do it is in the Form 8. Legal trap number 4, incorrect Form 6 procedure. Okay, this is fairly basic, but we still see situations where there is an incorrect procedure adopted. The agent must give the Form 6 to the seller before selling or doing anything in connection with the sale. The seller must sign it, and the agent must give a copy of the signed form back to the seller. So if you don't do that, it's an offence, and it's just not worth taking those risks. And the same caution is deserved in relation to reappointments. It's not appropriate to go back and change the date on the Form 6 and say the exclusive agency, cross out the old date and put in a new date 3 months hence. That's not really satisfactory. What should be done is the provision for reappointment in the form should be utilised, and issue a new form and get the new form signed in relation to the reappointment. Okay, well, I think we've covered 15 of we've got 3 to go. Legal trap number 3, not explaining a sole or exclusive agency. Not only must the Form 6 be given, and must a copy of the signed Form 6 be given back to the seller, but there's an obligation on the agent to discuss the sole or exclusive agency with the client. There's an obligation to discuss the proposed term, obligation to discuss that the seller has an entitlement to negotiate how long the sole or exclusive agency will go, and there's an obligation to discuss with the seller the consequences if the property is sold by another person during that period. So we see plenty of situations where sellers say this didn't happen, and they were sent a copy of the Form 6, or it was conducted without any discussion whatsoever. So that's an offence, and it can have significant consequences. So just beware of that as legal trap number 3. Okay, now before we go on to the last 2, I'd just like to get a feel. What issues do you see most important in terms of these legal traps and compliance generally? Having satisfied buyers and sellers is important. Getting the commission due is important. Not getting sued, compliance with regulation. All right, so we're getting a good proportion saying all of the above. Thanks for your input on that. We'll close that off in a moment. Okay, so you see there that a big proportion think all of those issues are important, although the most important are obviously compliance with regulations and not getting sued. All right, well, I see we have a number of questions. First question, before we go on to the last 2, let's answer a few questions. When a listing agreement or contract is signed by an enduring power of attorney, how does that change the paperwork? There is no change to the paperwork. It simply means that the attorney should specify that they are acting as attorney for so-and-so. So just saying as attorney for is sufficient. If you want to be sure about things, you should ask for a certified copy of the power of attorney, just so you know that the person signing the document has authority. Okay. Must an agent / developer provide a Form 8 where there is no benefit being received? Answer is no, they need not do that. Let's see, we've got another question here. Okay, we'll come back to the remaining questions. Not getting indemnity from a seller. Now, this is something you might not have thought of as being a legal trap, but indemnity from a seller as to the accuracy of their instructions and statements that you're going to put in advertisements is critical to your commercial relationship. I mentioned before that you want to get the seller to sign off on those instructions, but you also need an indemnity. Now, it's not included in any of the standard Form 6 terms that I've seen, but it is a critical piece of your risk matrix that needs to be put in place in every transaction. And in the case of the Riparian Plaza litigation, it would have saved that agent a lot of trouble and a lot of heartache. Not to mention the adverse publicity from a Supreme Court decision that at least 2 of which have been published so far. Okay, now see what else we've got before we go to number 1. Can you tell me, how do you rate your organisation's contract presentation and compliance and forms compliance at this stage? From excellent down to below satisfactory. Okay, good to see those responses coming in. Good to see there's some room for improvement. Okay, we'll close that off now. Thanks for your responses. So there we have it. Some agencies striving for excellence, and I hope after today that you can also find things that you can add to your processes that will be of benefit. Okay, so legal trap number 1, boom boom. Not using the latest version of the contract. Okay, I've mentioned this as we've gone through. The 2 new versions of the contract are out at the moment, and they accommodate mainly electronic conveyancing. The REIQ contract also puts in that, reverses quite nastily, I think, the situation about land tax adjustments. So that's what the REIQ, the new REIQ contract accommodates. ADL, they accommodate electronic conveyancing, but they've also included the provision about Dropbox documents being able to be exchanged. So we've seen in litigation where a party said that they sent documents within a particular time limit by electronic means. The court said no, you didn't, because you didn't. Dropbox doesn't fit within the definition of electronic transaction within the Electronic Transactions Act. So ADL have developed a provision there to accommodate that technological development, and we're seeing a lot of contracts exchanged by Dropbox these days rather than email. So the consequences there are potential, certainly in relation to not accommodating electronic conveyancing, could pose some liability. It's more than likely, though, that the argument will probably be about land tax. It could be said by a buyer that if you're using a buyer who didn't want to be adjusted their land tax and pay some of the seller's land tax after July, could point the finger and say, why didn't you use REIQ version 11 and I would have got out of it. So it's probably not a huge liability exposure there, but it is something that best practice requires using the latest versions to accommodate the big savings, we hope, savings in time and hopefully eventually dollars that will flow from electronic conveyancing procedures. Okay, so that completes the legal trap run through. Just a reminder that this webinar will be posted on our website, and you can view it again or ask others to view it from your office within. It'll be up there within an hour or two. You can also subscribe to the Agent Developer and Investor e-news. That's also you'll find that on the blog section of our website, the subscribe facility. And you can also download a free wall chart relating to the Property Occupations Act contract preparation and contract presentation procedures. So that's available for download free of charge. Okay, thanks once again. Our next webinar will be in mid-July, and in the meantime, happy selling.